Hello and welcome to CU150, the show about technology, innovation, and entrepreneurship. I'm Tim Montague, your host, and I'm joined today by Joe Murphy with Meyer Capel. Thanks for being here, Joe.
Thank you.
Why don't you start off by telling us a little bit about your practice and the law firm itself? I know of you as an intellectual property attorney, and you do more than that. So tell us what you do and what the firm does.
Well, as Tim said, I am an attorney at Meyer Capel, law firm. Meyer Capel has been a law firm here in Champaign since the early 1960s. We recently celebrated our 50th anniversary. I have been with this firm since 1994, and I actually grew up in Champaign, but I was gone for 16 or 18 years practicing, going to school and practicing in other places before I came back here from Washington, D.C. in 1994 to pursue telecommunications as a practice and intellectual property as a practice. So my own personal practice, a little more than half of it is telecommunications, which is largely phone companies fighting with phone companies, or internet and ISP-related companies and networking companies, and how those networks interconnect and how people get compensated. But the other part of my practice, which brings me more into touch with entrepreneurs, is my intellectual property practice. So as an intellectual property lawyer, I do copyright, I do trademark, I do trade secret, I do patent licensing, but neither I nor this firm prosecute patents. So when you get down to the very nature of how do you go about getting a patent, it is certainly something that we here at Meyer Capel know a lot of people who are capable of doing, and we put our clients in touch with, but that's not part of our direct practice. Licensing patents, however, which is something that comes up frequently in the university context. When you have a new startup, that is something that we have done with the university time and time again.
So from an entrepreneur's perspective, somebody who has an invention, no matter really the stage of development of that, but they're thinking about commercializing an invention. What are the issues that they are dealing with, and what are some of the issues that they should be thinking about that they might not be thinking about?
So I'll put this in the university context, as we have the University of Illinois here, which is just an engine of entrepreneurship. So if you are, I'll just say you're a faculty member who's working in your lab on something that you say, you know, I've created something, I've developed something, I think it has commercial potential. Your first thought should be the intellectual property here, particularly if it's patentable, is intellectual property that's actually owned by the university. So your next step is to go to the Office of Technology Management and identify, and then they've got forms and a whole process to do this, but identify the intellectual property, what it is, why it's patentable, why it's novel. They'll take you through all that. And if they agree and decide that this is patentable, they will decide when and how to pursue a patent. If you think that this is something you want to commercialize, your next step is to say to the OTM, I would like to commercialize this, and you probably need to think about how you're going to do this work outside the university, because whatever work you continue to do inside with your university facilities and your university phone and your university office, that continues to generate property that's owned by the university. So you want to think about getting outside office space, whether that's in your home, using your own computer, using your own phone, so that you develop that outside face of your company, and at the same time come back to the OTM and say, I would like to license the technology I've created. The OTM has forms and formats, the things they go through, and their question to you is going to be, what are your plans for commercializing it? Because they're perfectly happy. It's their mission to get this kind of technology out and commercialized. But they're going to be asking you and looking at you for your particular plans so that they can satisfy themselves that your commercial plans are actually going to be successful or have a likelihood to be successful. They will give you a form of license, so you need to be thinking about that. That's one of the points when you might want to get an attorney involved. If you are going to take on other investors, or if there is more than one of you in the company, which is commonly the case, you know, it's pretty frequent that there'll be several faculty members or faculty members and certain grad students. Right. You are going to want to think about how you interact, whether you're going to set up a corporation or an LLC, and that is I'll put that on the shelf for a minute. It's certainly something we do here at Meyer Capel, and I and my partners help people through that, but that's not really the intellectual property aspect here. But you're going to want to probably set up a company and consider how that company is going to get funded and who's going to do all the work. But you, as the face of that company, or somebody as the face of that company, is going to interact with OTM and get a license. And they're going to, you can expect that once you tell OTM what your business plan is, that the license will reflect some of those elements. So, for example, depending on your technology, if you say that this is 1 year from market or 2 years from market, you can expect those signposts, those deadlines to be in your license saying that you have an obligation to bring it to market within 1 year or 2 years. Mm-hmm. And what OTM's goal there is to say, if this is your plan, we need to know that it's really working. You can expect that you'll pay them some kind of a royalty. Of course, if you're the faculty member who invented this, I guess you can enjoy the fact that when the royalty comes into the university, there's a system that you will actually get some part of the university's royalty if it comes back into your department. Mm-hmm. But that's another issue. Mm-hmm. But anyway, the license may have an ownership interest in the company for the university. But when dealing with the university, they have their forms of license. It's certainly a place where you might want to get a lawyer involved, and you certainly want to understand what your obligations are under the license. But when you go back and negotiate with them, you need to know, or you need to think about what are the important elements of this, because as with any large entity, the university is no different. If you go back changing commas and putting things because you like this better than that, that will take amounts of time for the university to digest and respond to. If there are important elements of the deal, you certainly want to do that. You want to make sure you get a deal you're comfortable with. But you don't want to be going back to the university with all sorts of small changes that don't have a significant impact, because you're just going to expand the amount of time it takes for the university to negotiate with you and probably not accomplish much. So once you get that technology licensed from the university and it's into your company, probably your next big decision, or this is a decision that went into your business plan, is whether this is a technology that you and your company can exploit directly, meaning you're going to build the product, you're going to make the product, you're going to sell the product. If it's a software product, you're going to set up the website to sell it, you're going to put the salespeople out in the field. That's one strategy. That's a direct sales strategy. But the other strategy that is pretty common is that your company is going to function as a developer and then look for some kind of a distribution model or a distributor or a big player in their industry and turn around and license the actual sale to them. That's another intellectual property-based license that is significant to you, because it's in the same way that the university has been asking you, what's your plan, how are you going to prove to us that you're going to diligently exploit all this? If you're going to take it out to market, how are you going to make sure that your licensee is diligently pursuing your software, is diligently out there selling it? And those are all license terms that you need to be paying close attention to.
It seems like the decision tree gets fairly complicated fairly quickly. Do you find that entrepreneurs wait too long before they talk to people like yourselves, or how, in general, what are you seeing?
What I commonly find, particularly with entrepreneurs coming out of the university, if this is their first company, their reaction is, how inexpensively can I do this, and how quickly can I do this? And that has its place, because you don't want to drown your company in too much help too early on. But frankly, to go and initiate these relationships, one with a law firm, maybe with an accountant, certainly with a banker, all of whom are professionals who can help ask you questions and make you think about things that you hadn't thought about, establishing those relationships early gives you the opportunity to decide what's most important, and frankly, most of those professionals would be willing to work with you if they see the vision you see, that there's value down the road. They can be very willing to work with you in a way that helps give you the services you need early in the stage, mm-hmm. with a good opportunity for a payback to them later in the stage. Mm-hmm. So, frankly, I think it's probably never too early to engage a lawyer, an accountant, a banker, to say this is what we want to do. And the first thing you need to find out from these professionals is what questions do I need to ask. So the conversation you and I are having are what questions do I need to ask about licensing things from the university. But I'm certain that a banker would tell you, here are some questions you need to ask about your ultimate business plan, because they're looking to see how can you be successful.
Right.
And an accountant is going to say, you know, if you're setting up your company this way, what questions do you need to ask to make sure that you don't have surprise tax liabilities that you could have avoided, or that you don't have, and this comes back around to the lawyers, that you don't have some questions about how you act as a company or how you interact with each other that you could have solved through a better formation agreement that really set out, you know, your role as A, B, and C, your role as E and F, you know, you're doing M through O, and people know what people are doing, and people know how to keep each other accountable. Those are all elements that should be taken into, they should be asked early and taken into account when you're forming whatever your entity is, so that you don't get into an argument a year down the road that we both said we were going to do something, and I do it when I said I was going to do, but you're not doing what you said you were going to do.
Sure. Expect the best, but plan for the worst.
Yes.
So, what is it that that really gets you up in the morning? What do you love about practicing intellectual property law?
I like it because it tends to be a novel issue every day. It is not always necessary for your attorney to understand the technology you're dealing with, but in my experience, it makes for a much better relationship between the entrepreneur and the attorney when the attorney has some pretty deep understanding of what the IP is or what the company's about. I mean, this is true for a transactional attorney. And for me, one of the reasons I wanted to become an attorney in the first place was so that I could spend my career learning other people's business and learning different businesses as I go on. I know a lot of professionals my age who are very good at their job, but they've been very good at their job for the last 15 to 20 years, and it hasn't changed very much. And one of the things I really like being an attorney is, you know, when somebody calls me with a brand new technology, and I was lucky enough to live through a lot of the initial internet boom, right? You know, and people who had questions that had to do with networking, which I had a unique ability to understand because of my telecommunications background. But then, you know, people talking about what you can do with a web page, what social media is about, how does email interact, what are all those elements. Those are, for lawyers, all very new questions, and they're questions that I was maybe not the first man in America to be asked, but I was one of the first sets of lawyers because I live here at the University of Illinois. Mm-hmm. How do these questions get resolved? How do domain names get distributed? Those are questions that came up here in Champaign in the 90s, and right, other people just started figuring them out about 2005. So, you know, to me, the exciting part about being in a town like this with technology like this is you are on a monthly, if not weekly or daily basis, confronted with people who have technology that nobody's ever thought of, and it, you know, it may be a simple licensing issue for the attorney, but there may also be completely novel questions about, you know, the privacy of privacy related to the use of drones. Mm-hmm. Nobody ever thought about that. You know, there are all these other recording and data mining questions that people here at the University of Illinois are very good at working through. Data mining creates all sorts of privacy issues and ownership of the data, ownership of all that information. Many of those are novel issues. There's not a law book out there that will tell you how to handle them. So the idea that we get to be on the front end of that is pretty interesting.
You think of companies like Google and how much access to information they have because of the role that they play in the internet now, right? They are one of the central warehouses of information. You can imagine how that gives them many advantages, and it's perhaps a slippery slope I mean, I don't know what is legal and what is not legal in terms of data mining. And you know, I know they're looking at the stream of information going between people, right? Because that's how they're feeding me advertisements that are specific to my interests. And they're looking at what I search on, they're reading my email and so forth, whether a human is reading it or a computer is reading it. But is that a becoming a problem, do you think?
Well, it is a problem. I mean, it's obviously there are opportunities, but there is certainly anybody who has noticed odd advertising come up beside their email and understands that Google or Yahoo is reading their email, as you say, and we're not talking about a person trying to pry into your life, but you know, that kind of data analysis, you know, this comes to me as a telephone lawyer. If a phone company said they were listening to your conversations to find out what you talk about, I'd say you can't do that, right? And yet, Narrative, Google, Yahoo, they do that. They do that kind of sniffing all of the time, and yeah, there's litigation going on about it.
And there are positive outcomes from that too, where they discover criminal behavior and then they alert the authorities.
Well, and some people think that there's positive outcomes. I mean, the fact that you are getting marketing that is actually relevant to you,
sure,
that can be viewed as a positive outcome.
Right.
But, you know, and then that's a fairly simple thing. But, you know, going back to entrepreneurs, I mean, another area that we probably ought to touch on is anybody who is creating a new product or new service is going to name it. Okay. And so then you're into a trademark issue, and trademark is another fundamental issue. It can be a service mark if what you're selling is a non-tangible service, but the law is the same and trademark can be used interchangeably. But once you think of your product or your company and you think of a name you want to use it, the two things that everybody needs to be concerned about, the first one is that it's not already being used. And luckily with the internet, you've got the capacity to go on to Google or Yahoo or Bing or anything else and search around to see whether the name that you want, whether anybody has a name that is, the technical term, confusingly similar. And that has to do with what kind of products they sell, so how close the name is, how close the products are. That's a place where you might want to get an attorney involved, and that is intellectual property that I practice and we practice here at Meyer Capel. Okay. You know, once you've satisfied yourself that it's not already being used, and there are formal searches that you can have done at a cost, and if it's sufficiently important, that's a good thing to do, but a lot of entrepreneurs are trying to start cheap. But once you've satisfied yourself it's not otherwise being used, then you need to satisfy yourself that it is a name that you can protect. And by protectable, you know, you can't sell, you can't protect the word glass for glasses. That's generic. So you want something that is a little more creative, a little more arbitrary or fanciful. So it's important that you get a name that once you put it out there, people see that name will associate it with your product. And you can pursue formal protection for that. But again, it's a good reason to talk to an attorney, because I see a lot of people who file federal trademark applications more than they need to or faster than they need to, because they don't understand the protection that they get simply by using their trademarks or their service marks. So that's just another aspect of intellectual property that most business startups need to think about.
Yeah. You referenced earlier the cost of working with attorneys, and for entrepreneurs who are bootstrapping, certainly they're very cost conscious. And what are the ways that you and your firm work with entrepreneurs to mitigate that?
Well, the first thing that many entrepreneurs are too shy to do, but they just need to get over it, is you start out by asking how much will this cost. So if you're going to call an attorney's office, and you know you see come-ons for personal injury attorneys that say free consultation, that question about what does it cost to find out how much it costs, that's an important question anyway. So if you're going to call an attorney and say, I have, you know, I'm thinking of starting up a company, I have a set of questions, how much will that cost me to come in and talk to you? And you may find out, depending on the attorney, that is something they can do on a reduced cost or even free, to say, let's scope the problems here. But then as you go forward, you just need to be ready to say, how much does you know, if you start a corporation for me, or if you file a trademark for me, or if you pursue a patent for me, or you're going to work with the university, can you give me an estimate of how much that will cost? And then at that point, it is conceivable, it is certainly possible that attorneys kind of on a case-by-case basis will say, you're talking about $2,000, $5,000, $10,000 worth of costs, and I'd be willing to go X far with you before you pay me, or that you pay me some amount every month, or that as long as you're paying, or as long as there's a horizon, I can work within that. Okay?
That makes it certainly feel more accessible. So I want to encourage all owners and entrepreneurs to get business and legal advice early in the process. That is, I would agree, that's very, very important. Unfortunately, our time is up, Joe. I want to thank you again for coming on the show. Really appreciate it. Hopefully we can do this again. And I'm Tim Montague with CU150 at the Small Business Development Center at the Champaign County EDC. We've been talking to Joe Murphy, who's an intellectual property attorney with Meyer Capel here in Champaign-Urbana.